Executive Summary to Volume 2. Our obstruction of justice inquiry focused on a series of actions by the President that related to the Russian interference investigations, including the President's conduct towards the law enforcement officials overseeing the investigations and the witnesses to relevant events.
Factual results of the obstruction investigation. The key issues and events we examined include the following. The campaign's response to reports about Russian support for Trump. During the 2016 presidential campaign, questions arose about the Russian government's apparent support for candidate Trump. After WikiLeaks released politically damaging Democratic Party emails that were reported to have been hacked by Russia, Trump publicly expressed skepticism that Russia was responsible for the hacks at the same time that he and other campaign officials privately sought information, and here is a redaction which indicates harm to an ongoing matter, about any further planned WikiLeaks releases. Trump also denied having any business in or connections to Russia, even though as late as June 2016, the Trump Organization had been pursuing a licensing deal for a skyscraper to be built in Russia called Trump Tower Moscow. After the election, the president expressed concerns to advisors that reports of Russia's election interference might lead the public to question the legitimacy of his election.
Conduct involving FBI Director Comey and Michael Flynn. In mid-January 2017, incoming National Security Advisor Michael Flynn falsely denied to the Vice President, other administration officials, and FBI agents that he had talked to Russian Ambassador Sergei Kislyak about Russia's response to U.S. sanctions on Russia for its election interference. On January 27th, the day after the President was told that Flynn had lied to the Vice President and had made similar statements to the FBI, the President invited FBI Director Comey to a private dinner at the White House and told Comey that he needed loyalty. On February 14th, the day after the President requested Flynn's resignation, the President told an outside advisor, "Now that we have fired Flynn, the Russia things is over," unquote. The advisor disagreed and said the investigations would continue.
Later that afternoon, the president cleared the Oval Office to have a one-on-one meeting with Comey. Referring to the FBI's investigation of Flynn, the president said, quote, "I hope you see your way clear to letting this go, to letting Flynn go. He is a good guy. I hope you can let this go," unquote. Shortly after requesting Flynn's resignation and speaking privately to Comey, the president sought to have Deputy National Security Advisor, National Security Advisor K.T. McFarland draft an internal letter stating that the president had not directed Flynn to discuss sanctions with Kislyak. McFarland declined because she did not know whether or not that was true, and a White House counsel's office attorney thought that the request would look like a quid pro quo for an ambassadorship she had been offered.
The President's reaction to the continuing Russian investigation. In February 2017, Attorney General Jeff Sessions began to assess whether he had to recuse himself from campaign-related investigations because of his role in the Trump campaign. In early March, the President told White House counsel Donald McGahn to stop Sessions from recusing. And after Sessions announced his recusal on March 2nd, the President expressed anger at the decision and told advisors that he should have an Attorney General who would protect him. That weekend, the President took Sessions aside at an event and told him to, quote, unrecuse, unquote. Later in March, Comey publicly disclosed to a congressional hearing that the FBI was investigating, quote, the Russian government's efforts to interfere in the 2016 presidential election, unquote, including any links or coordination between the Russian government and the Trump campaign. In the following days, the president reached out to the Director of National Intelligence and the leaders of the Central Intelligence Agency, hereinafter called the CIA, and the National Security Agency, hereinafter called the NSA, to ask them what they could do to publicly dispel the suggestion that the president had any connection to the Russian election interference effort. The president also twice called Comey directly, notwithstanding guidance from McGahn to avoid direct contacts with the Department of Justice. Comey had previously assured the president that the FBI was not investigating him personally, and the president asked Comey, quote, to lift the cloud, unquote, of the Russia investigation by saying that publicly.
The president's termination of Comey. On May 3, 2017, Comey testified in a congressional hearing but declined to answer questions about whether the president was personally under investigation. Within days, the president decided to terminate Comey. The president insisted that the termination letter, which was written for public release, state that Comey had informed the president that he was not under investigation. The day of the firing, the White House maintained that Comey's termination resulted from independent recommendations from the Attorney General and Deputy Attorney General that Comey should be discharged for mishandling the Hillary Clinton email investigation. But the president had decided to fire Comey before hearing from the Department of Justice. The day after firing Comey, the president told Russian officials that he had, quote, faced great pressure because of Russia, unquote, which had been, quote, taken off, unquote, by Comey's firing. The next day, the president acknowledged in a television interview that he was going to fire Comey regardless of the Department of Justice's recommendation, and that when he, quote, decided to just do it, unquote, he was thinking that, quote, this thing with Trump and Russia is a made-up story, unquote. In response to a question about whether he was angry with Comey about the Russian investigation, the president said, quote, as far as I'm concerned, I want that thing to be absolutely done properly, unquote, adding that firing Comey, quote, might even lengthen out the investigation, unquote.
The appointment of a special counsel and efforts to remove him. On May 17, 2017, the acting Attorney General for the Russia investigation appointed a special counsel to conduct the investigation and related matters. The president reacted to news that a special counsel had been appointed by telling advisers that it was, quote, the end of his presidency, unquote, and demanding that Sessions resign. Sessions submitted his resignation, but the president ultimately did not accept it. The president told aides that the special counsel had conflicts of interest and suggested that the special counsel therefore could not serve. The president's advisers told him the asserted conflicts were meritless and had already been considered by the Department of Justice.
On June 14, 2017, the media reported that the special counsel's office was investigating whether the president had obstructed justice. Press reports called this, quote, a major turning point, unquote, in the investigation. While Comey had told the president he was not under investigation, following Comey's firing, the president now was under investigation. The president reacted to the news with a series of tweets criticizing the Department of Justice and the special counsel's investigation. On June 17, 2017, the president called McGahn at home and directed him to call the acting attorney general and say that the special counsel had conflicts of interest and must be removed. McGahn did not carry out the direction, however, deciding that he would resign rather than trigger what he regarded as a potential Saturday night massacre.
Although the series of events we investigated involved discrete acts, the overall pattern of the President's conduct toward the investigations can shed light on the nature of the President's act and the inferences that can be drawn about his intent. In particular, the actions we investigated can be divided into two phases, reflecting a possible shift in the President's motives. The first phase covered the period from the President's first interactions with Comey through the President's firing of Comey. During that time, the President had been repeatedly told he was not personally under investigation. Soon after the firing of Comey and the appointment of the special counsel, however, the President became aware that his own conduct was being investigated in an obstruction of justice inquiry. At that point, the President engaged in a second phase of conduct involving public attacks on the investigation, non-public efforts to control it, and efforts in both public and private to encourage witnesses not to cooperate with the investigation. Judgments about the nature of the President's motives during each phase would be informed by the totality of the evidence.
Statutory and constitutional defenses. The President's counsel raised statutory and constitutional defenses to a possible obstruction of justice analysis of the conduct we investigated. We concluded that none of those legal defenses provided a basis for declining to investigate the facts. Statutory defenses. Consistent with precedent and the Department of Justice's general approach to interpreting obstruction statutes, we concluded that several statutes apply here. See Title USC Section 1503, 1505, and 1512, subsection 3, 1512, subsection C2. Section 15112, subsection C2 is an omnibus obstruction of justice provision that covers a range of obstructive acts directed at pending or contemplated official proceedings. No principle of statutory construction justifies narrowing the provision to cover only conduct that impairs integrity or availability of evidence. Sections 1503 and 1505 also offer broad protection against obstructive acts directed at pending grand jury, judicial, administrative, and congressional proceedings, and they are supplemented by a provision in Section 1512B aimed specifically at conduct intended to prevent or hinder the communication to law enforcement of information related to a federal crime.
Constitutional defenses. As for constitutional defenses arising from the President's status as the head of the executive branch, we recognized that the Department of Justice and the courts have not definitively resolved these issues. We therefore examined those issues through the framework established by Supreme Court precedent governing separation of powers issues. The Department of Justice and the President's personal counsel have recognized that the President is subject to statutes that prohibit obstruction of justice by bribing a witness or suborning perjury because that conduct does not implicate his constitutional authority. With respect to whether the President can be found to have obstructed justice by exercising his powers under Article 2 of the Constitution, we concluded that the Congress has authority to prohibit a President's corrupt use of his authority in order to protect the integrity of the administration of justice.
Under applicable Supreme Court precedent, the Constitution does not categorically and permanently immunize a president for obstructing justice through the use of his Article 2 powers. The separation of powers doctrine authorizes Congress to protect official proceedings, including those of courts and grand juries, from corrupt obstructive acts regardless of their source. We also concluded that any inroad on presidential authority that would occur from prohibiting corrupt acts does not undermine the president's ability to fulfill his constitutional mission. The term, quote, corruptly, unquote, sets a demanding standard. It requires a concrete showing that a person acted with an intent to obtain an improper advantage for himself or someone else, inconsistent with official duty and the rights of others. A preclusion of, quote, corrupt, unquote, official does not diminish the president's ability to exercise Article II powers. For example, the proper supervision of criminal law does not demand freedom for the president to act with a corrupt intention of shielding himself from criminal punishment, avoiding financial liability, or preventing personal embarrassment. To the contrary, a statute that prohibits official action undertaken for such corrupt purposes furthers, rather than hinders, the impartial and even-handed administration of the law. It also aligns with the president's constitutional duty to faithfully execute the laws. Finally, we concluded that in the rare case in which a criminal investigation of the president's conduct is justified, inquiries to determine whether the president acted for a corrupt motive should not impermissibly chill his performance of his constitutionally assigned duties. The conclusion that Congress may apply the obstruction laws to the president's corrupt exercise of the powers of the office accords with our constitutional system of checks and balances and the principle that no person is above the law.
Conclusion. Because we determined not to make a traditional prosecutorial judgment, we did not draw ultimate conclusions about the president's conduct. The evidence we obtained about the president's actions and intent presents difficult issues that would need to be resolved if we were making a traditional prosecutorial judgment. At the same time, if we had confidence, after a thorough investigation of the facts, that the president clearly did not commit obstruction of justice, we would so state. Based on the facts and the applicable legal standards, we are unable to reach that judgment. Accordingly, while this report does not conclude that the president committed a crime, it also does not exonerate him.